today's episode, we are going to Indiana, USA. The date is the 18th of August, 1987. On this day, 15-year-old Sean Lamont Rowe and 13-year-old Ronald Lee Sanford were walking through their neighborhood in the hope of doing some yard work in return for money for the Indiana State Fair. They ended up at the house of two sisters, Anna Louise Harris and Julie Belmar. This interaction would have a deadly conclusion, and 13-year-old Ronald Sanford would be staring down the barrel of a 170-year prison sentence. Hey everybody, and welcome to episode 5 of the Student's Verdict podcast. Thank you for joining me. For those of you who are new, my name is Emily and I'm your host. If you haven't already, please go and listen to our earlier episodes, which include cases such as the Monster of Worcester and the cases of Kanika Jenkins and Kendrick Johnson. Also, please follow us on Instagram at the Student Verdict blog and on Twitter at Student Verdict. Resources used in this episode will always be linked in the show notes. If you enjoy the show, please rate and review, and if you don't enjoy it, then never mind. With all of that said, let's get started on today's episode. On his cell wall, Ronald Lee Sanford has the phrase, "No man is your enemy, no man is your friend, every man is your teacher." In an interview with WTHR, a 40-year-old Sanford recalled feeling terrified walking into Michigan City Prison when he was just 15. But how does a juvenile end up in prison at just 15? Sean Lamont Rowe, 15, and Ronald Lee Sanford, then 13, had decided they were going to get money for the state fair. They set about finding work that might earn them that money. This was their goal as they approached the 300 block of Harvard Place, the home of two elderly sisters, Anna Harris, 83, and Julie Belmar, 87. Rowe and Sanford suspected that the women had money, so when the boys' offer of yard work was rejected in a split-second decision, they decided to force their way into the home. It's believed that the women were tortured and beaten before they were murdered, and their bodies were left in the basement. Both sisters had been stabbed to death multiple times. Rowe would later leave the sisters' home with just $5 for the fair. After the deaths of the sisters, neighbors were understandably fearful. In one newspaper, a neighbor said the following, quote, "They, criminals, haven't invaded us yet, but it's getting too close to home. We have contact with the police through our neighborhood watch. At least we know who to call if anything looks suspicious." In 1988, a year after the murders, Sean Rowe was arrested. Upon his arrest, he immediately requested a plea deal where he would testify against Sanford in exchange for a lesser sentence. Rowe denied involvement in the murders, claiming that he was a bystander. As a result of his plea deal, most of the charges against Rowe were dropped. He was therefore only charged with assisting a robbery, to which he entered a guilty plea on the 22nd of March 1989. For his part, Rowe received a sentence of 5 years, 11 months, and 30 days. In March 1988, the state charged Ronald Lee Sanford as a juvenile for his role in the stabbing deaths. In April 1988, the court sent Sanford's case from the juvenile to the adult court, where he was charged with 2 counts of murder, 2 counts of Class A felony robbery, 2 counts of Class B felony criminal confinement, 1 count of Class A felony burglary, and 2 counts of felony murder. As his trial approached, Sanford was advised by his public defender to plead guilty to the charges of double murder, robbery with bodily harm, and burglary on the understanding that his age and lack of conclusive evidence would be taken into account. Remember, the state's case relied heavily on the testimony of the co-defendant, Sean Rowe. There was little independent evidence to corroborate who played what part in the events that unfolded on that August day in 1987. In March 1989, Sanford, now 15 years old, entered guilty pleas to the 2 charges of murder, 1 count of Class A felony robbery, and 1 count of Class B felony burglary. The remaining charges were dismissed by the state. The plea agreement left sentencing open. The following month, in April 1989, the court sentenced Ronald Sanford to 50 years for each count of murder, 50 years for robbery, and 20 years for burglary. The judge explained that these sentences were to be served consecutively, as opposed to concurrently, which amounted to a sentence of 170 years in total. Under his sentence, Sanford would not be eligible for parole until the year 2070, when he will be 96 years old. I think we need to look at how a 13-year-old becomes involved in a double murder in the first place. We'll start by looking at Ronald Sanford's background. Ronald Lee Sanford was born on the 12th of February 1974. When describing being raised in a single-parent household, Sanford said that he had no consistent fatherly influence growing up, as his mother's boyfriends would come and go. His mother, Pamela Johnson, experienced issues with alcoholism, which caused her to act out physically. With the violence he experienced in his childhood, Sanford described to interviewers feeling like he was trained to kill. When asked to elaborate, a now 40-year-old Sanford said the following, quote, "It's easy to get to the violence when you have already been in the gas. When you've been in the violence, it's easy to be violent. Children become what they see. They mimic the examples they follow." It should be noted that since his incarceration, Sanford's mother has received help. She's clean and sober and went to school for nursing. Ronald Sanford and Sean Rowe became friends as they both attended Short Ridge High School. They were described fondly as close buddies, but the principal, Alfred Finnell Jr., recalled them as a tough guy and his follower. He said that all Sanford's teachers experienced problems with him, but Sean Rowe only acted out if Ronald was there. Sanford was taller than Rowe and was said to be the leader of a group at the school. Principal Finnell said, quote, "Often a lot of kids will look up to the tough guy image. A lot of kids become followers of those types of individuals. I'd say Sean would be the follower in this case." To the reporter, the principal went on to set out Sanford's disciplinary record, which included 2 suspensions the autumn before and nearly 6 weeks' worth of absences. Sanford was failing his courses when it was discovered that he had moved from his mother's address at 301 Harvard Place to his grandfather's on 1425 North Mount Street. When her son was implicated in the murders, Sanford's mother said, quote, "Not in my wildest dreams. I don't know why they picked Ronald. He's a good child, and a 13-year-old couldn't do something like this." It was later alleged by Sanford that on the day the murders were committed, his mother had left him home alone as she had left town for the weekend with a boyfriend. Sanford's police record included arrests for beating one schoolmate and threatening another with a knife. According to state corrections records, Sanford's criminal history started at the age of just 10, with an arrest for theft on the 14th of August 1984, just 3 years and 4 days before the murders of Anna Harris and Julie Belmar. The theft charge would be dismissed after restitution was made, but 2 years later Sanford was arrested for attempted burglary. This was later reduced to criminal mischief and he was placed on probation. On the 1st of January 1987, he was arrested for battery with injury. He was committed to the Indiana Boys' School, but the punishment was suspended. 5 months later, he was arrested for theft while on probation. Again, he was given a suspended sentence. It was because of his lengthy criminal record that the deputy prosecutor said they felt that a 13-year-old Ronald Sanford was beyond rehabilitation. Before we start talking about the legal stuff, I'd just like to preface this by saying that although I work in criminal defence, I'm a trainee solicitor in the UK and not the United States, where this case is set. I've conducted research into the relevant case law, which we will be discussing, but I am by no means an expert. Now, in civil matters, state and federal laws recognise the immaturity and irresponsibility of children. For example, you have to be at least 18 to vote, sign contracts, or to serve on a jury, and you need parental consent to get married. Yet, in the criminal justice system, a juvenile, so that's someone under the age of 18 and even as young as 10, who commits a crime can be treated as an adult. Under international law, sentencing children to die in prison is condemned. The Juvenile Law Centre says that life without parole and other extremely lengthy sentences keep these juveniles in prison well past the point at which they have been rehabilitated and well beyond any reasonable risk of reoffending. Before 1980, life without parole was rarely imposed on children, but the number of child offenders who received this sentence each year began to increase in the late 1980s. By the end of 2016, there were 2,310 people serving life without parole sentences for crimes committed as juveniles. Now, on to the case law. In the case of Roper v. Simmons, 2005, the Supreme Court ruled that juveniles could not be sentenced to death, writing that the death penalty is a disproportionate punishment for the young. Following this case, 12 states banned the death penalty in all circumstances and 18 more banned it for juvenile offenders. This case affected 72 juveniles on death row. Between 1976 and the Roper case, 22 individuals were executed for crimes committed as juveniles. In Graham v. Florida 2010 case, the Supreme Court banned the use of life without parole for juveniles not convicted of a homicide. The ruling applied to at least 123 prisoners. The court called life without parole an especially harsh punishment for a juvenile. For example, where a 15-year-old and a 70-year-old are both sentenced to life without parole, the saying life without parole will have very, very different meanings for both of those defendants. Finally, in the cases of Miller v. Alabama and Jackson v. Hobbs, 2012, the Supreme Court held that for juveniles, mandatory life without parole sentences violated the Eighth Amendment. That's the one that says cruel and unusual punishments should not be inflicted. Finally, in the case of Montgomery v. Louisiana, 2016, the court ruled in favor of Henry Montgomery, who had been imprisoned in Louisiana with no chance of parole since 1963, after receiving a conviction when he was a juvenile. The court held that prisoners previously given automatic life sentences with no chance of parole for crimes committed as juveniles must have their cases reviewed for resentencing or be considered for parole. Alison Parker, a senior researcher with Human Rights Watch, summed it up nicely by saying, quote, "Kids who commit serious crimes shouldn't go scot-free, but if they are too young to vote or buy cigarettes, they are too young to spend the rest of their lives behind bars." So what are some of the issues in Ronald Sanford's case? I wanted to cover this case for two reasons. The first is that out of all the articles I've published on the Students' Verdict blog, the case of Ronald Sanford still gets the most attention by far. I think it's a really thought-provoking case, which leads me on to my second reason, which is that Ronald Sanford's case is in stark contrast to another case that was covered, we covered earlier in the Students' Verdict podcast, which was the case of the Monster of Worcester.